today with the Law School Clinical Assistance for Tribal Domestic or Tribal VAWA 2013 Special Domestic Violence Criminal Jurisdiction. And I just want to welcome everyone to the webinar and mention that if you look on the right side of your screen, wherever the information is about the webinar, there is a section labeled handouts, and it's second to last right below the chat. And if you take a look there, there are 5 handouts, and these are some of the resources that we will be discussing today during the webinar. There should be 5 comparison of the 5 pilot tribal VAWA tribal codes, a fact sheet, a model code, tribal law and policies, TOLOA VAWA resource, and tribal code development checklist. So those will be referenced throughout the webinar, so please take a look at those and download them when you get a chance. Also today we will be fielding questions throughout the webinar, so feel free to raise your hand at any time or type in a question, and we will try to get to those questions throughout the webinar. And we will also have time for Q&A at the end of the webinar as well. Today we have a number of presenters. We have Sarah Deer, Professor of Law, 2014 MacArthur Fellow from the William Mitchell College of Law. We also have Michelle Demmert, Reservation Attorney from Tulalip Tribe. We also have Brent Leonard, Attorney from the Confederated Tribes of the Umatilla Indian Reservation, as well as John Dossett, General Counsel from the National Congress of American Indians, Kelly Gaines Stoner, Victim Advocacy Legal Specialist from the Tribal Law and Policy Institute, as well as the Honorable Steve Aycock, Judge in Residence from the National Council of Juvenile Family Court Judges. Quickly, our presentation today, just here's a quick outline. We'll look at how law clinics can assist with code drafting, a quick overview of VAWA 2013 Special Domestic Violence Criminal Jurisdiction, as well as reference to the Intertribal Technical Assistance Working Group. We'll then look at the Tribal Code Checklist and a comparison of the 5 pilot project tribes codes. We'll also look at some common problem areas in VAWA code drafting, and then turn to the Tribal Legal Resource regarding Tribal Law and Order Act and VAWA, as well as the model code developed by the 3 pilot project tribes. And again, we'll have time for more questions, but again, please feel free to ask questions throughout. And with that, I would like to turn it over to Sarah Deer. Thank you.
Thank you so much. I'm really pleased to be able to explain a little bit about how our clinic here at William Mitchell works. I have to give a lot of credit to Pat Sikyakwaptua and Carol Goldberg, who taught me about this kind of clinic at UCLA several years back. Our clinic here is made up of 2nd and 3rd year law students who have a track record of interest in working with tribes. So those students enroll in our clinical program. We have our clients, which are tribal nations that are seeking to improve their codes or maybe even draft their first criminal code. The students are expected to research that tribe, ask good questions of the tribal leadership, and then develop a plan to help the tribe with their codes. So it's free for tribes, which is great. But it's also a great opportunity to start training the next generation of attorneys to work respectfully and effectively with tribal nations. So tribes receive that free code writing assistance over the course of a semester. And what's great about what students are able to do is, rather than cut and paste or copy and paste from an existing code, we can really work to customize a statutory scheme that makes sense for the tribe. The other thing we can do is tap into the tribal culture, if it's appropriate, to make sure that principles and philosophies of the tribal nation are reflected within the code that they draft. Usually what we do is come up with a number of different options based on the feedback we get from the client, and then offer choices and different schemes and statutory structure that the tribes can then choose from. So we welcome inquiries from tribes about how we might be able to help, and we also like to spread the word among potential law students that this is a viable opportunity for them, and that it will lead potentially to being able to work with tribes as they leave law school and enter their legal career.
Thank you, Sarah. Next, we will be going over the Special Domestic Violence Criminal Jurisdiction, and I'd like to turn it over to Steve Acock.
Good afternoon, everyone. So one of the nice things about VAWA 2013 is that it didn't just say we're giving tribes this authority. It said that we are affirming their inherent authority to exercise criminal jurisdiction over non-Indians. It's important for a couple of reasons. Number one, it's important because it strengthens the tribe's sovereignty, but it also then takes out any consideration as to whether or not this is some sort of delegated authority from the federal government, and because if it was, then there might be some concern about double jeopardy problems. But because it's affirming this inherent authority, it's not. And the other thing that's nice about the way the statute is written is that every tribe gets to decide for themselves whether they want to exercise this jurisdiction or not. There's no requirement that any tribe do it. There's no penalty for any tribe that either does or does not do it. The only thing is there are some specific requirements that are necessary. And as I said, it doesn't change either the federal jurisdiction, it doesn't change state jurisdiction. So if your state already has the authority under PL 280 to exercise jurisdiction on the reservation under certain circumstances, this does not change that authority at all. So the statute defines both dating and domestic violence because it covers both of those. So it covers dating violence, also covers domestic violence. So you can see here those definitions. The important part, I think, in the dating violence is that it's this social, it's not, right, it's a romantic or intimate relationship. And in the domestic violence, it's got to be a spouse, an intimate partner, a person who they share a child in common, or if you have cohabited or are cohabiting with the victim, and then a person similarly situated to a spouse. And then it has to be where the violence occurs. I mean, the violence has to occur in the Indian country that's doing the prosecution. So there's also a piece that talks about violation of protection orders and protection orders. So in the old statute, there was explicit language that said that tribes could enforce protection orders regardless of where they were issued. The new statute just clarified, it didn't really change the law, but it clarified that it also means that tribes can issue protection orders against any person. And so part of what this slide does is it talks about what the definition of a protection order is. And it's broad. So it's any injunction order issued by any kind of court for the purpose of preventing violence or threatening acts or harassment, or sexual violence, contact, communication, physical proximity to another person. As you can see in this bottom one, the third bullet there, it only applies for violation of protection orders if the violation of the order is, the violation is of that portion of the order that protects against the violence or threats or harassment, sexual assault, was issued against the defendant, is enforceable by the participating tribe, and is consistent with full faith and credit, which basically says you have to have personal jurisdiction, you have to have subject matter jurisdiction, and the individual has to have the required due process notice requirements. There are also some much broader due process requirements now than many tribes are currently granting. So you have to give all the applicable rights under the Indian Civil Rights Act, which hopefully you're already doing. If there's a term of imprisonment, then you have to also grant them all the rights under the Tribal Law and Order Act. And then there are some additional rights from VAWA itself. And those are that you have to provide effective assistance of counsel, and you have to provide those free for indigent defendants. The judge has to be a law-trained judge who are licensed to practice law, and it doesn't really define what those mean in terms of what is a law-trained tribal judge and what license do they have to practice law. So we think that if you are a judge who is licensed by your tribe, that may be sufficient. But to be sure and to have best practice, it's probably best to have a judge who is licensed in the state or the federal courts. But we're not sure exactly what that's going to pan out over time. You have to make your laws, your rules of evidence, your criminal procedure, all of that has to be made public. Again, hopefully everybody's already doing this, but you have to maintain a record of the proceedings. So you either have to have audio or video recordings of the trial proceedings. You have to have the right to a trial by an impartial jury. You have to grant that. This is where a lot of questions have arisen, because what exactly is an impartial jury? And it has to be drawn from sources that reflect a fair cross-section of the community, including non-Indians. So what does it mean, a fair cross-section of the community? We've had lots of discussions about that, and I think some of the handouts will cover part of that. And then they have a right to habeas corpus. And the right to petition for a stay of detention. And there's, again, some confusion, and maybe others on the panel can say what they think about this, but I know that at least one of the tribes they are handing the defendant at the time that he's booked into jail a written notification of the rights, including this right to habeas corpus and the right to petition for a stay of detention. Am I doing this slide? I'm sorry.
Sorry, Steve. Yeah, we don't have anyone from Pasquayaki, if you don't mind.
Oh, sure. So Pasquayaki was one of the first 3 tribes that got approved as part of the pilot project, and they actually did the first jury trial under this new statute. And since February of last year, when they were approved, they've had 21 of these cases involving 15 separate offenders, 6 convictions. As you can see, a quarter of their DV cases is non-Indians. And there's some very concern about 18 children were involved as witnesses or victims, because the statute right now requires that you, as you saw, either have a dating relationship or have an intimate partner relationship of some sort. And of course, the children in the house don't have that. So to the extent that they are victims, this jurisdiction, this inherent authority of the tribes does not include that. And then what you'll find is in a lot of these, I think in all of the cases you're going to see the non-Indian defendants have had multiple tribal police contacts, arrests, or report over the last several years. So these are not people that were unknown and came out of the woodwork only upon this new statute, but that were well known to the police and the community on the reservations.
Thank you, Steve. Michelle, would you like to discuss Tulalip's cases?
Sure. Good afternoon. So at Tulalip, like Pasquayaki, we have had a tremendous impact by exercising special DV jurisdiction. So far, we've had 10 cases since 2014, February 2014, and I think it's pretty interesting to lay out some of the demographics of our defendants as well as some of our victims. So, as Steve said, many of these individuals have had numerous contacts with law enforcement over the years, so they aren't new to the tribe by any means. In 8 of our cases, the defendants had had over 100 contacts with law enforcement since 2008, and we haven't compiled the statistics for the remaining 2, but some other interesting statistics. The age of the defendants range from 21 to 35, and there are 3 Caucasian, 3 African American, 3 Hispanic, and 1 unenrolled Canadian Indian. 5 of the defendants have children in common with the victim, and as far as who the victims are, of our 10 cases, 8 are the current girlfriend to the defendant, 1 is a spouse, and 1 is an ex-spouse. In 6 of our cases, children were present at the time of the crime, and 2 children were actually victims of the crime by either being assaulted or endangered in some significant way. Our DV prosecutor, Sharon Jones Hayden, has done a tremendous job with her DV investigator, and thus far she has negotiated 6 guilty pleas. 2 cases are now pending. 1 case was dismissed for lack of sufficient evidence. 1 case was so serious that we have transferred it to the federal court, who will exercise primary jurisdiction over crimes against the victim and the child. And then once they're done, we are going to reclaim that case and prosecute the defendant on the violations of the protection order. Thank you.
Thank you, Michelle. Now I'd like to turn it over to Brent to discuss the Umatilla Indian Reservation crimes.
Great, thanks. I'll be relatively quick on it. We've had 4 cases, 4 arrests. The first case was an assault, and the person was booked into jail, released with an automatic protection order we have, and then he violated the protection order. So the first 2 cases were the same defendant, but different incidences. There have been 3 convictions, and the 4th case is still pending, likely going to go to a plea in the next month or 2. The first defendant, who had the first 2 charges, or first 2 cases, was put on probation for the majority of his time with a suspended sentence, was ordered to batter intervention treatment, and was given several opportunities to comply, failed to comply, and I think last week he had his 320 days imposed. So he's serving a year. And that's where things are at right now. In terms of the statistics we've had from our family violence program before VAWA passed, it indicated that there were a high degree of people who were seeking services from family violence program for cases involving non-Indians, although very few of them would report to the police. There were probably 60% of the cases seen by the program in 2012 that involved non-Indians. So the fact that we've had 4 cases in the last year, a little over a year, is pretty significant. It's a lot higher than has ever been prosecuted by the U.S. Attorney's Office in a year or 2, and it's higher than any had been reported in the past involving non-Indians. So I think that the adoption of VAWA has provided more safety to victims, and certainly it appears that they're more willing to go to police to have the matters dealt with. So that's the situation at Umatilla.
Thank you, Brent. I'd like to turn it over to Kelly now to discuss Eastern Band of Cherokee, which I believe is very recent.
Thank you. Good afternoon, everyone. This is Kelly Stoner with TLPI. And although the Eastern Band of Cherokee Indians were not one of the original 5 pilot tribes, since the pilot phase is over, specifically on June 8th of 2015, the Eastern Band of Cherokee implemented VAWA 2013 tribal jurisdictional provisions. And since that time, they have 1 prosecution and 1 conviction under VAWA 2013. The tribe issued a press release, which you can find online. It's a 2-page press release. It's very interesting information. And it indicates that John Michael Arkansas, 55, was convicted on July 21, 2015 for 1 count of special domestic violence criminal jurisdiction. The cause of action or the charge was violating a domestic violence protection order. He was sentenced to 75 days imprisonment, and it was suspended for 1 year. The defendant was placed on supervised probation and ordered to pay a special fine of $1,000 in addition to $600 in restitution to the victim. And the press release, it's interesting listening to what Brent Leonard had to say. The press release also indicates that it is the Eastern Band of Cherokee finds it troubling that in domestic violence cases involving child abuse and child victims, that VAWA 2013 is not going to cover that. And so that's still a gap that the tribe is concerned about. Thank you.
Thanks, Kelly. I could briefly go over the Intertribal Working Group known as ITWG. It was launched by the Department of Justice as a part of the pilot project. And it's, we've had a number of in-person meetings and webinars, and it's a group of tribal representatives who discuss their work on the special domestic violence criminal jurisdiction. It's been very informative, and people have been able to exchange their views and discuss what they've been working on and how they've gotten through some issues, and it's just been very helpful. And we really encourage those, maybe whoever's online, if your tribe would like to be a part of it, to please have them contact, I guess, myself or Virginia, and we could get you in touch with folks at the Department of Justice, specifically the Office of Tribal Justice, and have you sign up to be a part of the group, because we will be holding another in-person meeting coming up in November, and most people feel it's been very helpful. And here's just a photo of everyone at the first meeting, which was in South Carolina, and this lays out some of the issues that we've gone over together as a group. And here again are the email addresses, so please feel free to contact us and join the Intertribal Working Group. And with that, I would like to turn it over to John Dossett.
Thanks, Gia. This is John Dossett with NCAI. I'm going to go over very briefly the checklist that was put together by the Intertribal Working Group. It was kind of a work product of the Intertribal Working Group on how the checklist is intended to help you as you write one of these codes. So, you know, writing the code is often the first step for a tribe that wants to get engaged in exercising special domestic violence jurisdiction, and this checklist is what we came up with. This is just a very abbreviated version on the slides. If you look over in the handouts on your right-hand pane, there's a full document, a long checklist, that includes references to examples from some of the pilot tribes. So you can use that to find the code sections that have already been written. Anyway, a lot of this work is already done, and that's what this checklist helps with. The first thing to think about is the tribal constitution. There are many tribes whose tribal constitutions limit their authority to exercising criminal jurisdiction only over Indian people and not over non-Indians. I think, for example, Fort Peck was one of the tribes. The first thing they had to do was amend their constitution with a tribal referendum before they could move forward. I should also add to that, in tribal constitution piece, sometimes the tribal criminal code will have a provision in it that limits tribal jurisdiction to only Indian people and not non-Indians. And that's, in some ways, it's like a statement of jurisdiction at the beginning of a tribal criminal code, and you may want to look there as well. Those may need to be amended or fixed up if the tribe is going to start exercising jurisdiction over non-Indians. So that's a big first step, is looking at the tribal constitutions. Secondly, is the definitions of the offenses. As Steve Aycock mentioned earlier, that these aren't jurisdiction for all purposes. They're very specific types of crimes, and it seems probably necessary that there's some sort of definitional aspect in the tribal code that would define what these crimes are. I suppose it would be possible to use just general assault crimes, but that would make life difficult for the prosecutors and others. So some sort of specific definitions are necessary, and of course those definitions come right out of federal law, so they can easily be adapted that way. The third major area, and there's a number of points here, are the rights of defendants, and that's maybe one of the most notable parts of the act, is that the tribes can exercise this jurisdiction as long as they protect the rights of the defendants, and there's a list of the rights that have to be protected. Steve has been through these already. The Indian Civil Rights Act, of course, is a long list of the rights of defendants. Many tribal codes, at least the ones that I've seen, already incorporate the Indian Civil Rights Act by reference, or they have very similar text in their code. But you should look for that. For example, the right to a jury trial, or a number of other things are found there in the Indian Civil Rights Act, and that should be included somehow. The jury pool to include non-Indians. This has been one of the areas that and I'll go into these slides next, where there are a number of different ways to include non-Indians into the jury pool. This could be included in the tribal code, or it could be included in a jury plan, but this element needs to be considered very carefully. And I think the tribal council may need to make some choices. There are a number of different ways to incorporate non-Indians and use different groups to include in the jury pool. The notice of the right to habeas corpus and the right to petition for a stay of detention, obviously that has to be protected. That's a part of the code. The right to counsel is very important and is part of the Tribal Law and Order Act and the Extended Sentencing Authority. The qualifications of judges, again, that could be included in the tribal code, or perhaps in a tribal judicial procedures, but it has to be included somewhere. The recording of proceedings. This could, once again, be procedural, or could be written in the code. I think most of the tribes have put it directly into the code, but this is one of the rights of the defendants, is the right to have the proceedings recorded. And then finally, the publication of laws. I believe that most of the tribes that have done this so far have published their criminal codes on the internet, so that they're readily available to everyone. But these are the major factors. All of these, like I mentioned before, are found in more detail in the checklist and in the statute itself. In addition to these mandatory items, there are a number of things that are probably very helpful to consider. And the first of these, of course, is victims' rights and victim safety. I suppose it is possible to have a criminal code that didn't address victims' rights and victim safety, but it's at least our understanding is, it's very difficult for prosecutors to get anywhere if they don't have victims or other people who are willing to testify against the defendant. This has been a very important part of the violence against women movement, and I'll get into this a little bit more. There's a number. I'm not going to go through all of these, but there are but when you look at the checklist, it's laid out in some more detail. There's a number of things that the tribe may want to consider adding to their code or adding to their procedures in order to better implement the law. And some of these are best practices that have been developed both in Indian country and outside of Indian country. And I'll move on to the next slide. on that one. I wanted to, another document that we produced that's included in the handouts is a bit of a comparison of the 5 pilot tribes and how they develop their codes and the differences among the 5 pilot tribes. I thought they were interesting because they highlight some of the choices that the tribe and the tribal council and the attorney who's drafting the code need to consider as they develop the code for the tribe. The first of these is the jury pool. One of the things that I think is most interesting is the way that these jury pools have been constructed. For example, Pasquayaki includes, and I think Tulalip both include tribal employees within the jury pool, whereas Umatilla, their jury pool is constructed from voter registration lists within the reservation. Both are legitimate ways of doing it, but they're just a different policy choice. But one of the key differences in this was that same jury pool for the first 3 pilot tribes, Umatilla, Pasquayaki, and Tulalip, they used the same jury pool for all crimes, Indian and non-Indian. And a big difference is Fort Peck and Sisseton, they decided to only use the expanded jury pool for special domestic violence criminal jurisdiction. So non-Indians would be sitting on the jury only when a non-Indian is up as the defendant. It's a different way of doing the code. I think there were some tribes who were concerned about including non-Indians on a jury when a tribal member was the defendant. So this addresses that, and I think it's important to look at and to consider. The right counsel is another difference. The first 3 pilot tribes guaranteed indigent counsel for all defendants, whereas Fort Peck and Sisseton, and particularly Fort Peck, guaranteed counsel only in cases of domestic violence and special domestic violence jurisdiction. So they don't provide counsel in the case of all defendants. Sisseton also has a slightly different twist on this. Provided counsel if available for all defendants, but then guaranteed it for special domestic violence jurisdiction. And there were other differences in the code. Oh, that's all right. I can go to my other version here. Oh, there you go. And, oh, judicial. I thought this was also an interesting, you know, the Tribal Law and Order Act for extended sentencing and for special domestic violence jurisdiction requires that that there be a law-trained judge, and it has some specific statutory language on that. All of the tribes that have done it so far have included judges who are licensed under the state bar, and that of course seems like it complies with the law. But one of them, Fort Peck, in its application to the Department of Justice, also included the chief tribal judge, who was not barred under state law, but he has an undergraduate degree and from a college. He is licensed in tribal court. He has 2 certificates from the Judicial College in judicial skills and trial court skills. So they're making an effort to qualify a judge to exercise authority over these cases without necessarily being a member of the state bar. I know that was contemplated when they developed the Tribal Law and Order Act, and here Fort Peck is working toward that goal. So that's another important one to consider. If you go to the next slide, I thought this was interesting, just the number of different ways that the tribal codes among the first 5 pilot tribes have worked to protect victims' rights and victims' protection. A number of different provisions that are provided are noted here. All 5 of the tribes have quite a lot going on, but it's worth noting those different and taking a look at those 5 tribal codes and the way they protect victims. The final thing I wanted to mention is that even though it's not required by the law, all 5 of those tribes provided public notice that they were going to exercise this jurisdiction. That public notice, I think, is an important part. If there were ever a challenge to the constitutionality of the statute, I think it adds weight to the tribe's argument if they've provided public notice, and the non-Indian was at least had the opportunity to be aware that they could be subject to tribal jurisdiction. I guess I'll leave it at that. Turn it back to Sarah or take any questions.
Thanks, John. I don't see any questions right now, so next I would like to turn it over to Brent for the common problem areas.
Great. I was asked to look at common problem areas when drafting codes for VAWA, and I really just started thinking about issues that came up when dealing with implementation of both TLOA and VAWA. So that's what I'm going to go through, and some of these John's already hit on. First and foremost, I think, is making sure there's not a barrier in the Constitution for the tribe to being able to implement VAWA, and in fact TLOA as well. If you're doing VAWA, you're probably going to want to think about being able to do felony sentencing as well, or at least have an eye toward that if the tribe ever wants to get there. And John mentioned Fort Peck. There's also Pasquayaki had a constitutional barrier for felony sentencing. It was 6 months maximum for any offense, so they had to go and do a constitutional amendment for that. So make sure you look at that. It may not be an issue, but if it is an issue, it's a complete barrier. So make sure you jump that hurdle. Next isn't really a problem, but it's a way I think you ought to approach thinking about when you're drafting a VAWA code or a TLOA code, kind of a perspective to look at things, and that's to consider how a federal judge reviewing a habeas corpus is going to look at it. Because ultimately, somewhere, VAWA is going to get challenged, and the question is going to be whether Oliphant is a common law decision or if it's actually constitutionally based, and whether VAWA is permissible. So, and judges are going to look at the codes, and they're going to have experience with federal systems and state systems. So it's important that it's drafted in a way that makes things clear also for them, I think. Next is, I think the biggest issue is determining how you're going to deal with potential tribal equal protection claims. So TLOA and VAWA TLOA has specific rights you have to give for somebody who's facing a felony versus a misdemeanor. In VAWA, you have to provide those same rights to a non-Indian for DV case or protection order case, whether or not it's misdemeanor or felony. So there's potential equal protection claim to those who don't get those rights. And you need to think about how to deal with that. I don't think it's an equal protection claim that you're going to see at the federal level or winning at the federal level because it's all statutory based, but I do think it's a very strong claim for anybody to take forward in tribal court. I think a tribal judge is going to have a hard time saying that a non-Indian is entitled to greater rights than a tribal member in tribal court. So think about how you're going to do that. And John went over some differences between the tribes and how they've done that. At Umatilla, everybody gets the same right, whether it's misdemeanor, felony, or non-Indian. And other places they've done kind of special domestic violence dockets, so everybody within that type of docket gets those same rights. Next is ensure that the prosecution is required to plead and prove beyond a reasonable doubt all the jurisdictional elements. This came up through the ITWG as things were moving forward. There are, all sorts of jurisdictional requirements for the non-Indian jurisdiction, and the question was whether or not you actually have to plead that in a charging document and prove it out, or if it's a defense for a defendant that the defendant has to raise, and then tribe would have to prove beyond a reasonable doubt. If you look at some of the federal laws, like the General Crimes Act and the jurisdictional elements that are essentially jurisdictional elements in that statute, you'll see the cases there really saying that regardless of whether or not it's jurisdictional or an element of crime, prosecution's burden is to plead it and prove it. So make sure you cover that issue. And in that regard, I think it's worth considering developing a pleading document or template to ensure that all the elements are hit, or all the jurisdictional elements are addressed when actually charging the case. So at Umatilla, we have basic outline pleading forms for each type of offense, domestic violence, dating violence, or violation of protection order. We don't actually file those in those cases, but we use this template to look at when filing a case. Next is keep an eye out for VAWA 2013's definition of domestic or dating violence versus the existing tribal definitions. I think this is a big issue. The definitions, if you look at them, talk about violence committed, and then they go on to talk about the nature of the relationship between the perpetrator and the victim. Violence committed is open to interpretation as to what it means. Unfortunately, there's a case called Castleman that came out. I mean, it was a great case for what it stood for, which was whether or not the term domestic violence in the federal firearms statutes included broad notions of domestic violence or very narrow definitions of crimes of violence under other federal laws, criminal laws. And it turned out that given the way the statute was structured, that the majority held that it was more the general notion of domestic violence by typical DV advocacy community and whatnot. Unfortunately, there are footnotes in there from Scalia and Sotomayor having an exchange on some of the issues, and they actually mentioned VAWA 2013's non-Indian provision specifically, and Scalia used it as evidence of statutes that narrowly interpret domestic violence. So something to look out for. I think there's an argument to say it is broad, that it isn't too limited, but it's probably not one we want to start pushing the envelope on until the Oliphant decision's decided. I think all tribes are taking a more of a cautious approach to this until those things are dealt with. So look at that and think about that. And also, similarly, the full faith and credit compliance for protection orders. Make sure you look up the full faith and credit laws under federal statutes and make sure that the tribe, at least the tribe that you're helping out, that their protection order and protection order process complies with full faith and credit. I think that's important. Next, timely notification of new habeas corpus rights. John mentioned that earlier. So in the new VAWA, there are new habeas corpus rights. A person not only has a right to habeas corpus, but they have a right to petition the federal court to stay the tribal court detention pending a habeas petition if there's a reasonable likelihood of success on a claim, if they show that. So in that, it also says that defendants are to be given timely notice of this right. So at Umatilla, what we've done is in every case where somebody is detained, they are actually given a written one-page form that says almost word for word what their rights are under the federal statute, and they sign it, or if they refuse to sign it, the police officer signs it noting that defendant refused to sign it. And since in every DV case it's a mandatory arrest, we get it to them very early. We're certain that it's reflective of what the statute says. They'll also get some notice when they go before a judge for probable cause hearing or arraignment. So that's something to think about. The right to defense on appeal came up as an issue. Certainly everybody here has a defense attorney on appeal if they want one, but it wasn't explicit in our codes or other court orders or court directives, but it was something that the Department of Justice raised question on. So that's something to look at and think about, making sure that's explicit somewhere, whether it's in a code or in a court manual. How long court maintains the record. Court has to have a recording of the proceeding. But again, when we got the early jurisdiction, one of the things the U.S. Attorney's Office was interested in knowing is how long we maintained the record. We didn't have anything formal in writing at that time, so we did a court directive that indicated what the practice was, which is 10 years. But that's something to keep in mind. You don't want a case to go through tribal court, exhaust all the remedies in tribal court, get into federal court on a habeas claim, and then have the record destroyed at some point along the way. So next is tribal habeas. This also came out through the ITWG process. At Umatilla, you have a right to appeal, and that right to appeal is throughout the code on direct appeal type issues. So, you know, somebody files a motion to suppress, judge denies it, they go to trial, lose, they appeal based on the incorrect ruling, claiming an incorrect ruling of judge, direct appeal. But there are cases where, say, ineffective assistance of counsel might be raised. There's no direct appeal there. That's the sort of case where you want to bring them before the judge and argue it outside of the pending case. And so what we did is we created a tribal habeas process to make sure that's covered. And I think that's important because if somebody takes a case into federal court on a habeas claim, that's beyond just a jurisdictional claim, and they try to make a claim that there's reasonable likelihood of success on the habeas claim, I think tribes are in a very strong position to say, if they haven't exhausted their tribal court remedies, that they can't show a reasonable likelihood, because under federal law, it's basically a hurdle they have to jump before they can make the claims. So they have to go back to tribal court and vet all their issues before tribal court for the tribe to have a chance to decide those issues. So a habeas process makes it clear that any potential challenge they have is available to them in tribal court. Next is comprehensive rules of evidence. When we're going through TLOA and VAWA, the tribal code at Umatilla, the rule of evidence was about 1 paragraph long, and it basically gave great discretion to the judge to decide whether or not something comes in or out. In practice, you know, anybody who had an evidentiary issue, they would usually look to federal or state rules of evidence in cases, in tribal cases, interpreting those and making their claims. But in the statute itself, it was really just 1 paragraph long. So we went through and developed comprehensive rules of evidence that are very similar to state or federal rules. Not identical, but very similar. And then lastly, I think it's important to really look at the criminal procedure and process that the court actually has, with careful attention to speedy arraignment and speedy trial. So you want to make sure that somebody who is detained gets before a judge in a reasonable amount of time, 48 hours, 72 hours, whatever it may be, to be able to have probable cause determination or arraignment if you do them at the same time. And also, you don't want somebody sitting around for 2 or 3 years and having their case still not charged. You need to make sure that they have a speedy trial right, and not just in writing, but also in practice, make sure that things are in place at the court to make sure those don't fall through the cracks, because those would be very bad fact patterns, again, if somebody files a habeas and challenges the whole thing. So those are the things to think about.
Thank you, Brent. We do have one question, and I'll just put this out there, and whichever presenter wants to answer it. We have a question. Do you know the status of VAWA implementation in Alaska in light of the fact that it primarily lacks Indian country?
Well, this is John. I guess I can try to address that. I mean, the major thing that's going on in Alaska is their work outside of Metlakatla. You're right. There isn't, you know, any Indian country or land that's held in trust by the federal government. But the Department of Interior has recently published a change in the regulations, the 151 regs, that would, you know, open the door to taking land into trust in Alaska. And that is, you know, an issue of major discussion up there. They were talking to the state, the new state governor, the new lieutenant governor, Byron Malott is a native person. So it's a major issue in Alaska, and hopefully that's going to develop where they'll be able to put land in trust and tribes can exercise this jurisdiction in Alaska. Very, very important developments going on in Alaska right now.
If I could add to that as well, this is Michelle. The Indigenous Women's Resource Center has been working with Alaska tribes on this issue, as well as I believe the Indian Law Resource Center in Montana, and so I would encourage checking their websites out, as well as the Attorney General just last week issued an opinion. The Attorney General for the state of Alaska issued an opinion as to whether or not the status of a tribal protection order. So they are sort of in the very beginning of exercising sort of even domestic violence jurisdiction in the context of how it relates with the state.
Maybe this is a good time I could throw in another. Kelly Stoner asked me to make a point that I mentioned earlier, that you may want to look at the tribal constitution or the tribal laws to see if there are any barriers in place that would prevent the tribe from exercising jurisdiction. In that context, you may want to look at the tribe's laws regarding civil protection orders. There are some tribe civil codes that limit their ability to issue protection orders for non-Indians. So that's another place you might look for a barrier that needs to be removed in order to exercise special domestic violence jurisdiction. I hope I covered that for Kelly.
Great, thanks everyone.
Thank you,
Now I will turn it over to Kelly right now.
I wanted to this segment of the presentation will go over a variety of resources that clinics might find particularly helpful when taking on the task of code revisions as it relates to TLOA and VAWA 2013. And the first you see on your screen there is found on the Tribal Law and Policy Institute webpage. It is a guide, and it has a unique philosophy to it that is more of a team-based with a variety of different possible tribal organizations and members to the team, so that it's hopefully encouraging the cultural piece, and the resulting code reflect the philosophies of the tribal community, as Professor Deere underscored earlier. So this is the table of contents. Oh, excuse me, this is the domestic violence law. It's also a code resource, but focusing on domestic violence. And this is the table of contents of it. You can kind of look down through there and see that this again is from the Tribal Law and Policy Institute. We try to be very broad as we're taking this approach to the domestic violence laws, trying to incorporate as many different topics as we think we can here. So if a tribe is really interested in, as John was saying, really looking at those domestic violence laws both in a civil and criminal context, that might be a nice resource for professors to access. And this I've already gone over, so we can go to the next slide. And this is the table of contents from the TLOA VAWA 2013 Special Domestic Violence Criminal Jurisdiction piece. You can kind of see the table of contents here. We wanted to provide that to you so you can kind of look through it and see if you think there are topics in there that might be particularly helpful to you. We'll go to the next slide. There's a segment that's talking about codes, laws, and rules, and criminal offenses, and publishing those laws and rules according to TLOA and VAWA 2013. There's different segments on defense counsel and judges, and as well as establishing a tribal bar association. Covering also tribal courts of record, jury trials, sentencing options, and then this habeas issue that Brent was talking about earlier. We also wanted to, in addition to those resources, kind of give you a list, if you will, of helpful resources as you approach code drafting. And so being mindful that the Indian Civil Rights Act has been amended by TLOA and VAWA 2013, so making sure you have the most updated section of the Indian Civil Rights Act or version, Model Tribal Court Code court rules, TLALIP domestic violence court rules, and there are TLALIP as well as the other pilot tribes, their application that was completed by the tribe in order to, when these pilot tribes were seeking approval from the Department of Justice to move forward as a pilot tribe and exercise this jurisdiction before all tribes were capable of doing so. So these, I think, would be very helpful. I know that some of these are in a handout that you're going to be getting after the presentation today. And also a consideration is for tribes and for clinics as they're assisting tribes is trying to move forward and decide how the tribe is going to handle domestic violence cases in general. If you go to the next slide, please, Chia. Determining whether the tribe would like to set up a DV court where all protection orders, perhaps civil and all criminal violations, will be held in cases involving domestic violence. And we've created a resource for that as well. There's a one-pager just kind of setting out the differences of a DV court versus just a DV docket. So you can kind of look down through there, and here are some really important, I think, ideas as you're thinking about code revisions as well, particularly making sure that there's a non-waiver of sovereign immunity clause in there, severability clause, savings clause, and those sorts of things.
Thanks, Kelly. And Michelle, in your help draft this model code, is there anything that you would like to discuss?
Sure. Thank you, Gia and Kelly. Yes, I wanted to sort of highlight the fact that the ITWG is really a very hard-working work group, and just at the December meeting in California, while the tribes were talking about, some of the tribes were talking about barriers they were running into as they were drafting their codes and trying to define a process, the 3 pilot tribes listened carefully to what the problems they were encountering were and came up with creating a model code during that meeting and to sort of solve some of the problems. A few of the problems that were identified included, and they've already been sort of identified here, is that for public defense, there's no budget to provide public defense for all criminal cases. Judges, sometimes there are part-time judges, sometimes there's lay judges, and sometimes there's law-trained judges. And so meeting those requirements could be challenging. And I believe that one of the biggest challenges some of the ITWG tribes were having in creating their codes, including the jury provision. Many of the tribal folks were really opposed to having a jury pool that included non-Indians universally for all criminal cases. And so listening to those sort of challenges and talking with some of our federal partners who have been very supportive during this process, we put together a model code and presented that on day 2 of the ITWG in California. The model code is primarily based on Tulalip's DV code, and it's really a self-contained code, meaning that we put it together in a way that all the requirements of 904 would be contained all in one short code section, so that we could sort of handle the issues with juries, public defense, judges, etc. And also, as Brent said, could be some tribal equal protection issues. So we wanted to make sure that we weren't affording non-Indians greater rights than what we were affording tribal folks for the same crimes. So in any event, we pulled provisions from the Tulalip code, and I believe that there is a copy of the model code in the handout section, and I'll just go over it briefly. The purpose, well, I don't think it's necessary that you have a purpose statement in a model code of this kind. I think it's important to consider it because it really sets the tone for what's to come, and also provides the judges with some guidance if there's any interpretation issues. But it just sort of frames everyone's perspective moving forward in exercising this type of jurisdiction. And so we included 2 paragraphs for a purpose statement. Second, we have a special domestic violence court created, and the reason why we did the court was to address sort of the equal protection issues and also to limit the scope of requirements that the special DV jurisdiction would need to provide. So in there you have the publication of the codes, the jury, and so things that may not apply universally for all of your court cases at the tribe. We listed the special DV criminal jurisdiction and cited to the specific U.S. code because, as Brent said, if there is a challenge to this jurisdiction, it's going to most likely go to the federal court, and they're going to be used to reviewing federal laws. And so what better way for them to review it than to see that we've adopted them? So that's one thing that we did. In terms of the rights applicable, we laid out all the rights for rights to the defendant, rights to counsel, right to jury trial, jury pool, presiding judges, and writs of habeas corpus. And all of those rights, while they're not in the Tulalip DV code, they were pulled from our general court provisions and can be found there. And then, let's see, I think what also is important is to demonstrate that, we kept it really simple in terms of the criminal conduct that's applicable, and limited it to the behavior that Judge Aycock and John mentioned in the checklist and in the overview of 904. So that's just condensed in a very short, succinct manner. And then, of course, as Kelly said, you want to have good, for any code, you want to have a statute of limitation mentioned, non-waiver of sovereign immunity, severability, and a savings clause. Those are all can be really important components to any code. So as I said, it's kind of a self-contained code that could be used. But of course, the cautionary note is that you always have to look at your code and your constitution to make sure that this sort of model code could be adopted to your tribe. But in any event, we were really excited to present that to the ITWG and hope that any or all of it can be helpful to all of the tribes that are interested in pursuing this sort of jurisdiction. Thank you.
Thank you, Michelle. We just received a question. Someone was wondering what a savings clause is. If you could explain that, please.
Sure. So when you have a new law, you have an implementation date, and so there's sort of this time period where you have cases that could be tried with the new law and cases that could be tried with the old law. And the savings clause just sort of clearly defines how the old cases will be treated and how the new cases will be treated. So there's not a gap in between the ability to provide that sort of sort of charge. And I think, if you look at the model code itself, you'll see, it's just very short, and it explains, I think, pretty easily and succinctly the purpose of it and how it would apply.
Thanks, Michelle. We have another question, and maybe Michelle or Brent and anyone else. Have any of the pilot tribes experienced any substantive challenges to its special jurisdiction over non-Indian that may be helpful for other tribes as they develop their processes?
This is Brent. At Umatilla, we haven't. Actually, the first case that was investigated so well and involved a confession that we tried to encourage the defendant to file an appeal in a federal court without any negative consequences to him on his underlying case in tribal court. Didn't want to do it. That's a guy who's sitting in jail for a year now, but wasn't interested in doing it. They appear to prefer going forward in tribal court than spending the time to fight it out at the federal level. So unfortunately, no. But I think the thing that is going to be most concerning is just a straight up Oliphant Lara question. And it will be, I'm hopeful that if a case goes up on that, and it will, that it'll be a clean case. So it's really only that issue, not other issues. A number of the other things that may come about are probably going to turn on, general due process issues and whether or not an evidentiary ruling was appropriate and those sorts of things. But we haven't had any challenges yet.
This is John. I think that I would just mention, I think that Pasquiyaki, they've had the most cases, and if I remember right, they had some early challenges to some of the procedural requirements that they had to deal with, like whether or not the code had been made available publicly. And so they had to deal with some of those in their early cases that they had to work through. But anyway, it's another good reason to work through the checklist and learn from what other tribes have been through.
And this is Steve Aycock. One of the other challenges that Pasquiyaki had is in their statute, it said that there would be public notice at the borders of the reservation, and they actually arrested somebody before those notices could get put up. So I think it's really important that when you're looking through the statutes that there aren't those kinds of hidden barriers that might end up tripping you up.
Thanks, Steve. We have another question here. Do we know of any cases that applied VAWA's special domestic violence criminal jurisdiction and TWG's enhanced sentencing?
The Sprint in
question
terms
is
of
whether
federal
they get
cases, I'm not aware of any.
sentenced to more than a year, but I sentenced a defendant, a non-Indian defendant, to longer than a year in prison for a single offense. I don't know if that's...
Oh, that's a question. I'm not aware of any this Sprint. We've had felony charge, but nobody who's actually been sentenced to jail beyond a year. But they certainly could because they've had suspended sentences longer than a year.
Great, thanks. Next, here's just a list of some of the resources that we have listed on the handout, and see, I believe they're all here, and then the websites as well, tribalprotectionorder.org and NCAI's Tribal VAWA webpage, and these are all great resources. I just would like to mention that I will email everyone these resources as well as the PowerPoint by tomorrow. And here is just a screenshot of the Tribal Protection Order website. So please feel free to take a look there and browse around. And here is NCAI's Tribal VAWA webpage. And with that, I'd like to turn it over to Sarah to kind of wrap up what we've been discussing and how law clinics can assist.
Sure. Well, I think for many tribal communities and tribal legal departments, you know, the workload has become almost insurmountable. And so the opportunity to work with law schools takes some of that pressure off of, you know, the day-to-day work of a legal department. We can do the research for you. We can, you know, use these resources to come up with sort of memos to the legal department or the legislative branch of the tribe. And, you know, the students get an opportunity to learn about some of the most innovative things that are happening on reservations. So we just wanted to make sure people know about the resource. Obviously, we've got some great publications out there. But you can also count on our law clinic to be supportive in your efforts as well. I think the most important thing I'd like to leave you with is, again, it doesn't have to be a cookie-cutter law. It doesn't have to be like everybody else's tribal law. As long as we meet the benchmarks that you're looking for, we can be creative and we can make sure that the code reflects tribal culture and tradition as well. So again, if you need to reach me, it is sarah.deer@wmitchell.edu, and we are still looking for tribes to support for the fall semester. So if you think we can help you, don't hesitate to get in contact.
I will just take a look here for any questions, and I don't see any. So again, I will send out the handouts that are available here, as well as the PowerPoint, and please feel free to email me with any questions and try to get everybody set up with the help that they need. And thank you all to the presenters. I appreciate all of your time and your expertise. So thank you, everyone, and have a great rest of your day.
Thanks, Gia.